Morning all. We're here for the appeal hearing in the matter CA12 2016 Peter Matthew James Gray versus Gibson, Dunn and Crutcher LLP before Chief Justice Michael Hwang, Justice Sir Jeremy Cooke and His Excellency Justice Ali and Madhani. The appellant is represented by Alba Wardy Critchlow. Lead counsel is Patrick Hennessy, assisted by Dr. Julian Critchlow. The respondent is represented by Gibson, Dunn and Crutcher LLP. Lead counsel is Graham Lovett, assisted by Ryan Whelan.
Hennessy, good morning.
Morning, Your Honours. As was stated, I represent the appellant in this matter. My learned friend, Mr. Lovett, appears on behalf of Gibson Dunn. Your Honours, before we move on to the substantive matters, I wanted just to check. You may have received an email yesterday afternoon attaching some further pages from Volume 1 of Mr. Bourne's volume on international commercial arbitration.
Did you say Gary Bourne?
Yes, that's right. These are in the authorities bundle. The respondent Gibson Dunn has relied upon certain passages from Gary Bourne, and we would seek to add to the authorities bundle the pages which precede and follow the extract inserted by Gibson Dunn. Now, I must accept that the rules of this court provide that any addition to the authorities bundle should be done no later than 48 hours prior to the hearing, and obviously in this case that hasn't happened, and for that I apologise. The rather prosaic reason, Your Honours, being that on receipt of the supplementary skeleton argument from Gibson Dunn, we undertook to procure the new edition of Gary Bourne. I got it just before leaving the United Kingdom, and we sought to have these inserted as soon as I arrived on Monday of this week. So I do apologise. I think, I won't speak for him, but I think my learned friend's position is that Gibson Dunn can't agree to have these inserted, given that the lateness of this request. So I'm putting myself in your hands, Your Honour, and asking that we can have these added to the authorities bundle so that I can refer to them to contextualise the points which are relied upon by the respondent. The only thing I'd say in support of this application, such as it is in my submission, it's uncontroversial that where one party refers to an extract from an authority, the other party should be able to, if necessity dictates, refer to the wider authority. And this is not a case where we're seeking to refer to a new case or a new authority. We're simply asking to have the pages in front and the pages behind put in.
Is they from the same volume?
Precisely, Your Honour. I'm grateful. In which case, may I hand up 3 copies of the relevant pages to Your Honours?
Lovett, while that's being done, any comments?
No. I did let my friend know we didn't object. It's just I'm not sure under the terms of the rules I could actually agree to the late submission, but we have no objection.
And I think, Your Honours, that they should go behind tab 21 in your authorities bundle.
Well, I'll put mine in when you refer to it, because if you don't refer to it, then it doesn't need to go in at all. Yep, go on.
Your Honours, pursuant to Rule 44.142, this Court will allow an appeal from a decision of the Court of First Instance, either where the decision of the lower court was wrong or where it was unjust because of a serious procedural or other irregularity. And this appeal is brought under the first limb of Rule 44.142, and we respectfully submit that the decision of the lower court on Gibson Dunn's application was wrong. The appeal is against both limbs of the order. The order stayed Mr. Gray's original DIFC court proceedings, and it made an award as to costs. Now, I note the very helpful suggestion in my learned friend's supplementary skeleton that the parties can make their respective submissions on the costs issue following your judgment. And so I would adopt that, and I don't intend to deal with the costs point that was raised. For this morning, I think we'll focus, if Your Honours agree, on the substantive issue, which is whether or not the Court of First Instance was right to award the stay. There are 5 grounds of appeal of the order for Mr. Gray that were developed in the skeleton argument for the appeal. Ground 1 was the learned judge's failure to have regard to the arguments as to the governing law of the contract. Ground 2 was the learned judge's failure to address the question of the definition of dispute. Ground 3 was the applicability of Article 12 of the arbitration law. Ground 4 was whether, as a matter of fact, on the evidence before the court, Mr. Gray had submitted to arbitration. And Ground 5 was the validity and enforceability of the arbitration clause. Now, Your Honours, you should have received, supplementary to all the bundles, my supplementary skeleton argument and the respondent's supplementary skeleton argument. And what I sought to do in my supplementary skeleton argument is to distill these 5 grounds of appeal into what, in my submission, are the key issues in this appeal, and that is whether or not, by reference to the DIFC arbitration law, the arbitration agreement relied upon by Gibson Dunn is valid or enforceable against Mr. Gray, and then whether or not Mr. Gray indeed agreed in writing to arbitrate the dispute or submitted to arbitration proceedings. Now, it is right, I think, to say that the question about the validity or enforceability of the arbitration agreement by reference to the arbitration law is a novel point, unless my learned friend is going to produce a surprise rabbit out of his hat. Neither side has found any authority directly on the point which is being argued before you today, which is whether or not the court can or should have regard to Article 12 of the DIFC arbitration law when it comes to considering the validity or enforceability of an arbitration agreement, in particular in respect of an application under Article 13 to stay proceedings because the arbitration agreement provides for a seat other than the DIFC. And in my submission, because this is the key question of law before this court, I'm going to start by addressing you on that point.
I don't have your supplementary skeleton. It's not in your balance bundle, is it? It's not in the hearing bundle?
I had understood it had been... it's dated the 29th of November 2016, and as far as I was aware, it was filed with the court on that date. May I just take some quick instructions on that? I don't have any direct instructions on that point. It was filed at around the same time as the appeal bundle, but I don't think it formed part of the appeal bundle.
I have the supplementary skeleton on behalf of the defendant respondent, 7th of December. Is yours after that?
Yes. No, Your Honour, mine would have been filed the week before that. As I say, it's dated 29th of November. If Your Honours don't have a...
15th of June, skeleton on behalf of the claimant.
Yes, so there's the... In Volume 1 of your appeal bundles, Your Honour, you will have at tab 3 the skeleton argument on behalf of the claimant for the appeal. That starts at page 9 of Volume 1.
Well, can you just give me a copy? Or, I don't know.
Yeah, Your Honour, what I'll do is I'll ask someone to go and make a series of copies.
None of us have it. Could you...
I do apologise, Your Honour. I'll do that straight away. Your Honour, someone will run some copies through
I mean, in fairness, Mr. Lovett's supplementary skeleton talks about your skeleton argument filed on the 1st of December?
1st of December.
Filed on the 1st of December. Presumably, that's the one you're talking about.
That is, yes, Your Honour, dated 29th of November. We'll have some copies run up now. This is clean, yeah. But
it's okay. We'll take it in our stride.
a rather good test of the extent to which I can remember my own skeleton now. I'll proceed without it in front of me, Your Honour. I was about to... what I'd said, Your Honour, I think where you may have lost me, because you obviously all began looking for a supplementary skeleton argument, which you didn't have, was that what I've done in my supplementary skeleton, which hopefully you'll get as soon as possible, is distill those 5 grounds of appeal down to these 2, what in my submission are key issues, namely the applicability of Article 12 of the arbitration law to the consideration of the validity or enforceability of that law. Your Honour, I understand you now have a copy of that document.
Yes, we have.
And so when it comes to referring to that, I'll do so. And I was just saying as well, Your Honour, that I think this is a point which hasn't been argued previously. There is reference, I should say at the outset, there's reference in the appeal skeleton and the grounds of appeal, and indeed there was argument before the judge at first instance on Pierre, Eric, Daniel, Bernard, Lease and El Seco Limited. And my own friend has some things to say about how much reliance we placed on that, but I do note that that is being heard on appeal before you following us today, so I'm not sure how much can really be said about that, given that that decision is under appeal. So we are dealing with a point of law which I think is novel before this court. And Gibson Dunn's case on this issue is straightforward. What they say is because the arbitration agreement contained in Mr. Gray's employment contract, which is also referred to in places as a letter agreement, because that provides for a seat which is other than the DIFC, they rely on Article 7, which is the scope of the DIFC arbitration law, and they rely on Article 7.2, which says Article 13, 14, 15, Part 4, and the schedule apply. And it may help to turn up the arbitration law, Your Honours. It's behind tab 3 of your authorities bundle, starting at page 84.
But the arbitration law.
This is the arbitration law, Your Honour. And on page 88...
Sorry, I'm using a loose copy. The section, please.
Section, part 2, Article 7. Part 2 is, Article 7 is the whole of Part 2. Part 2 is the scope of application of the DIFC arbitration law.
Yep.
And Article 7 provides that subject to paragraphs 2 and 3, the law applies where the seat is the DIFC. And then 7.2 provides that Articles 13, 14, 15, Part 4, and the schedule of this law applies where the seat is other than the DIFC. And as I said, Gibson Dunn's case is straightforward. They say that because the seat is other than the DIFC, on a plain reading of Article 7, the only articles, the only provisions of the DIFC arbitration law which can apply are 13, 14, 15, Part 4 and the schedule, and therefore what is said is that the court is not permitted to have any regard to Article 12 at all. If Article 12 could be considered by this court, then it would be said in Part 7, in Article 7, and it's not there, so in effect you can't. And there was extensive argument on the application, and reference was made to Injazat and Al-Fatan, which are the authorities which considered Article 13 before the amendment to the arbitration law. And Gibson Dunn explained the history of the amendment, being that where previously this court had to determine whether it had an inherent jurisdiction to stay non-DIFC arbitration proceedings, the amendment following those cases was to bring things in line with the New York Convention. And that's uncontroversial. And what we say is it doesn't actually assist on this question one way or the other. My submission is that though there's a superficial attraction to Gibson Dunn's case on the scope of the application, when you consider Article 12 itself, and when you look at the detail of the arbitration law, it is incorrect. And not only can the court have regard to Article 12, even where the arbitration agreement provides for a seat other than the DIFC, in my submission, it must have regard to Article 12. And I'll explain why that is. Your Honours, Article 7, on page 88 of the bundle, Scope of the Law, expressly provides that the articles which apply to a non-DIFC seated arbitration are 13, 14, 15, the whole of Part 4, and the schedules to the law. The schedules start at page 107 of your authorities bundle, page 21 of the arbitration law amendment law if you're using a loose copy. Schedule A provides for the rules of interpretation, Schedule B provides for the calculations of period time, and Schedule C provides defined terms. And you'll see that the first defined term, Your Honour, is arbitration. An arbitration for the resolution of disputes conducted pursuant to an arbitration agreement, capitalised, as defined at Article 12 of this law. The first submission on behalf of Mr. Gray on this appeal is that Article 12 is expressly brought into consideration by reference to the schedules. And if you look at Article 12 itself, that is unsurprising. Article 12 is not if you look at articles which don't apply to foreign seated arbitrations by virtue of the scope of the application, Article 16 prescribes the number of arbitrators, Article 17 provides the appointment of arbitrators. Of course, these are not matters on which the DIFC courts would weigh in for a non-DIFC seated arbitration. But Article 12 in my submission is different. Article 12 is the mechanism for defining arbitration agreement at all. So if you look, for example, at Article 12(3), the DIFC arbitration law provides that an arbitration agreement defined, capitalised, shall be in writing. And of course, it's uncontroversial that that is consistent with the New York Convention. Now, what Mr. Gray relies upon is Article 12(2), and what we say is you can't determine the enforceability or the validity of an arbitration agreement for the purposes of the exercise you undertake in respect of Article 13 without looking at Article 12, and specifically without looking at Article 12(2). And that's because if you look at Article 13, which Gibson Dunn rely on, Article 13(1) says if an action is brought before the DIFC court in a matter which is the subject of an arbitration agreement defined. In order to consider whether or not the matter is the subject of a defined arbitration agreement, the court must look at Article 12 as a matter of common sense, because that's how it's defined, and also by reference to the schedules, which bring it specifically in to the scope of the law which applies to non-DIFC seated arbitrations. And two examples in my submission suffice to show why Mr. Gray's contention on this point must be right and Gibson Dunn's must be wrong. The first, Your Honours, is this. If we consider for a moment that Gibson Dunn was not a law firm, but a DIFC business, a purveyor of furniture for expats who come into rented accommodation for 2 years for their job. And if we imagine that Mr. Gray was a consumer, if Gibson Dunn's contention is right, and Mr. Gray as a consumer enters into an agreement for the lease of furniture with Gibson Dunn sofas, and Gibson Dunn inserts on page 40 of some long set of terms and conditions a foreign seated arbitration clause, Timbuktu, then on Gibson Dunn's case, Mr. Gray as a consumer cannot rely upon the protection afforded in the DIFC by Article 12(2), which provides for limited non-arbitrability of consumer contracts. If Gibson Dunn is right, and this court is simply not allowed to look at Article 12, then it has no way of saying, well, hang on, the DIFC has specifically carved out in respect of consumer contracts that those can't be enforced without limitation.
Where do you say the definitional part of arbitration agreement is? 2, as opposed to 1 and subsequent paragraphs.
Well, Your Honour, we say that Article 12(1), well, Article 12 has to be read together, and that Article 12(1) provides you with arbitration agreement in inverted commas, and that is, as I said, consistent with definitions in the New York Convention. And then an arbitration agreement referring future disputes between the exceptions carved out at Article 12(2) provides whether or not those agreements will be enforceable. And I think what is raised in my learned friend's skeleton argument is this idea that there's been a confusion between validity and enforceability, and that was one of the reasons why I asked to insert those extra passages from Mr. Bourne's book, because where I think this confusion arises is Gary Bourne uses the term substantive validity and invalidity, and that is by reference to the carve-outs at Article 13, under which an arbitration agreement may be null and void, inoperative or incapable of being performed. But the key issue, Your Honours, in my submission in this case is one of enforceability. And what we say is you have to consider the enforceability as a condition precedent, because if the arbitration agreement is unenforceable because it comes within defined limits of non-arbitrability, if I may use that slightly inelegant term, and the non-arbitrability limits in the DIFC arbitration law are set out here at Article 12(2), then in my submission, on one analysis, either you don't get to Article 13 at all, because we're saying, well, hang on, this is an agreement that cannot be enforced against Mr. Gray because he's a consumer. It cannot be enforced against Mr. Gray because he's an employee and he hasn't consented in writing. Or, if you do get to Article 13 in my alternative submission, then it will be relevant to whether or not the agreement is null and void, inoperative or incapable of being performed, that it deals with something which this court and this jurisdiction has placed limits on the arbitrability of.
Slightly different, because you've drawn our attention to Schedule C, and definition of arbitration, and an arbitration agreement as defined in Article 12. Two.
Yes, sir.
But what I'm asking you is where the definitional element is, 2, as opposed to other parts of the article.
Well, Your Honour, in my submission, there's no breakdown of Article. Article 12 has to be read in toto for the definition. So, for example, Article 12(3), which we're not arguing about, provides that the arbitration agreement has to be in writing. Now, there are valid arbitration agreements in jurisdictions. There can be valid arbitration agreements in certain jurisdictions which aren't in writing. But in terms of defining arbitration agreement for the purposes of the DIFC arbitration law, and indeed consistent with the New York Convention, what is said in Article 12 is, well, for it to be an arbitration agreement so defined in this jurisdiction, it has to be in writing. So in my submission, you read Article 12 all the way through for the full definition of arbitration agreement within this jurisdiction.
You accept that there's a difference between definition and form of arbitration agreement, which is
I accept, Your Honour, that that is what is said at the heading. In my submission, that doesn't provide that any part of Article 12, sub 1, 2, 3, 4, 5, 6, or 7 is not relevant to definition and form. And Your Honour, if I can develop that must be right, because this was the second point that I was about to make, which in my submission supports our interpretation and undermines Gibson Dunn's, is that, again, if you were not permitted to consider Article 12, it would be open for Gibson Dunn to come to this court and say, we want to stay under Article 13, and we're relying on an unwritten arbitration agreement, which we allege has a seat other than the DIFC. And if you accept that there is a seat other than the DIFC in this unwritten arbitration agreement, you're not allowed to look at Article 12 of your own arbitration law, which says, well, hang on, it's not an enforceable, it's not a valid arbitration agreement for the purposes of this law. So, Your Honour, in response to your question directly, yes, there is a distinction in the heading between definition and form, but in my submission, those two can't be read separately for the purposes of consideration of the arbitration agreement that you're being asked to examine for the purposes of Article 13. And again, you can develop that point, if I may briefly, Your Honour, by looking at the provisions which, again, we're not arguing about further down in Article 12. So Articles 12, 5, 6 and 7, one might broadly say those go to form, if we're drawing that distinction that Your Honour raised between definition and form. So what the arbitration law here says is that an arbitration agreement is in writing, so it will comply with that requirement if it's contained in an exchange of statements of claim and defence. Article 12.7, the reference in a contract to a document containing an arbitration clause, constitutes an arbitration agreement in writing. These are provisions which will prevent usually a party from saying, well, hang on, there wasn't arbitration agreement because it was exchange of letters or because it was by reference to a different document. Now, of course, those go to form, but in my submission, they also go to definition, because what this court would say is, well, I hear your arguments, but I think this is a valid arbitration agreement. It's an arbitration agreement as defined by this law, and therefore I can go on and undertake the consideration in Article 13. And, Your Honour, this may be an appropriate place. If you could turn, please, to tab 10 of the authorities bundle, which is the Injazat case. This was the decision of Justice David Steele, and this was arguably the case which gave rise to the amendment to the arbitration law, because the learned judge didn't consider that he had a jurisdiction to grant the stay, because Article 13 at that point was not expressly stated to apply to foreign-seated arbitrations. And in that case, the seat of the arbitration agreement which was being argued over was Dubai rather than the DIFC, hence it was a non-DIFC seated arbitration. And one of the arguments that was raised before the learned judge was whether or not he should consider the validity of the arbitration agreement under DIFC law, notwithstanding that it was a Dubai-seated arbitration agreement. Now, he didn't consider that he had to undertake that process because he didn't think he had a jurisdiction, inherent jurisdiction to award the stay. But if you look at paragraph 39 of the judgment, which is at page 219, what the learned judge says there is, for the sake of completeness, I must now turn on the question of whether, if I am wrong, and there is in principle a discretionary jurisdiction to stay proceedings under DIFC law, on the basis that the DWS has exercised the option, whether or not a stay is appropriate where ITF have asserted that no valid arbitration agreement was entered into. Now, there's no reference made to Article 12, but the consideration that he undertakes at paragraph 40 is clearly an exercise of, by reference to provisions of Article 12, is there a valid arbitration agreement? For my part, I would regard this case as a paradigm example where it's appropriate to determine on the evidence filed that an arbitration agreement was duly concluded. And he refers to the exchange of letters, contemporary emails with documents attached, and a lack of comment. So in my submission, the exercise that was undertaken there by the learned judge was the correct one, albeit it was academic in that case. Had he been wrong, and had he been required to consider under DIFC law whether there was a valid arbitration agreement, of course, he had regard to Article 12. Because if it hadn't been in writing, then there wouldn't have been a valid arbitration agreement. If the contentions being advanced on behalf of ITF were made out on the evidence, then that would have been another reason not to grant a stay under Article 13, not simply that he didn't have a jurisdiction. So I draw that to your attention, because in our submission, that is the process which is appropriate for the court to undertake when considering a stay under Article 13, even where it's a non-DIFC-seated arbitration. Now, I made the submission earlier that there is a distinction, it's a distinction that Mr. Lovett seeks to draw out in his skeleton argument, and it said there's been confusion between the concepts of enforceability and validity. And I referred to Mr. Bourne's language of substantive invalidity, which refers to the sort of internationally accepted contractual bases on which an arbitration agreement will not be recognised as valid. And what Gibson Dunn rely upon, and what is in your authorities bundles behind tab 21, starting at page 453, tab 21 of the authorities bundle, page 453. Your Honours, you'll see there that the extract relied upon here starts at page 138 of Mr. Bourne's textbook. And what I've handed up to you in the clear plastic sheets is actually initially the 5 pages before this section. So this is a subsection of the section in Mr. Bourne's text on the substantive validity of international arbitration agreements. So if you remove, within that plastic sheet, you'll have various sets which are stapled together so that the place is not lost. And the first set of stapled together sheets will be page 833 through to page 838. So you get the 5 pages that precede this. And why I've asked to have this added, and why we say this is relevant, although I pause for a moment there to make the observation that, of course, this is a helpful commentary, but it is no more than that. This is Mr. Bourne's commentary. It's not authority, it's not binding on this court in any way, but it is perhaps useful in terms of clarifying some of the points, particularly in circumstances in which both parties have alleged in respect of skeletons that the others are confused. So to the extent that Mr. Bourne helps us shine a light and introduce some clarity, then he's to be gratefully received. But if you start on page 833, Your Honours, this is the lead-in to the section on the New York Convention which Gibson Dunn rely on. And as you see there, halfway down the page, this is the 506 section is the substantive validity of international arbitration agreements. Now, what Gibson Dunn appear to be saying in their supplementary skeleton argument, and I'll come on to this point in greater detail in a moment, is that the objections to the arbitration agreement that Mr. Gray raises are not capable of falling within the null and void, inoperative or incapable of being performed criteria, which are set out in Article 13 of the DIFC arbitration law, and which are borrowed verbatim from the language of the New York Convention. But in my submission, and I'll develop it later as I say, that is incorrect. But more broadly, what that narrow focus on null, void, inoperative or incapable of being performed does is it blinds you to the question of enforceability, which in my original submission I said was the key question here. If the arbitration agreement is not enforceable against Mr. Gray, either because it falls into one of those categories or separately but linked to that because it strays onto an area which the DIFC court has said is non-arbitrable within certain procedural limitations, then it's simply unenforceable against him. So where we say it's invalid, and the references to validity, particularly in the skeleton argument for the original application, that is simply to say it's invalid for the purposes of the application under Article 13, not specifically as Mr. Bourne defines it in terms of substantive invalidity. If you turn to page 834 in that first extract that I've handed up, about a third of the way down the page, in the second paragraph, sort of halfway through the second paragraph, just after footnote 1076, this, I think, is what my learned friend is driving at, where he says that there's a lack of clarity, and what Mr. Bourne says is issues of substantive invalidity are related to, but distinguishable from, cases where arbitration agreements are unenforceable in particular courts as applied to a narrow range of non-arbitrable subject matters. And the footnote that follows that, 1077, refers to subsection 5.07, which I'll take you to. And of course, what we say is that is precisely the arena we are in now. The DIFC, as a jurisdiction, has elected that there will be a procedural limitation, a procedural block on the arbitrability of employment contract matters. It doesn't say employment is not arbitrable at all. It's not in the territory that the UAE federal law is in. It's not in the territory of the law of England and Wales, subject to the Employment Rights Act. It doesn't say you can't arbitrate employment matters at all. But neither is it in the territory of certain jurisdictions of American states, where they say, well, this is totally arbitrable and we have no limits. What the DIFC says is, well, you can arbitrate subject to agreement. And so we say that falls squarely within one of the cases that Mr. Bourne refers to there, where an arbitration agreement won't be enforceable subject to certain limits.
In the text.
Well, I'll take you on through that now. So the reference in that footnote is to 507 following. If you look over the page at 836, what I'm doing, Your Honour, if that's acceptable, is I'm just developing first this distinction between substantive invalidity and the non-arbitrability of a dispute, and I will then take you to where Mr. Bourne says that employment matters and consumer contract matters fall squarely within one of the recognised ranges that national courts frequently apply certain limits to. So as I said, over on 836, which you should have, subsection 6 is the distinction between the substantive invalidity of an arbitration agreement and the non-arbitrability of the dispute. And halfway down that paragraph, the reference to Article 5.2a of the New York Convention, where an otherwise valid arbitration agreement is unenforceable as applied to particular matters. And again, that's simply the same point that we're making. This is not, because it's being said by Gibson Dunn, I think, in the supplementary skeleton, that what Mr. Gray is saying is, well, we're limiting a party's freedom to agree to arbitrate, or somehow that we're presenting a case which would place the DIFC in conflict with the New York Convention. And that is not what is being done at all. Parties are free to agree to arbitrate an employment dispute, subject to the procedural requirement that the employee agrees in writing. I also direct Your Honour's attention in this section on the distinction to the final paragraph over the page on page 837. This is in the middle of the page. In contrast, the effect of the non-arbitrability provisions of Article 5.2a and Article 2.1 of the Convention is to provide an escape device that permits individual contracting states to impose limits on the enforceability in local courts of parties' agreements on the law governing their arbitration agreement.
Paragraph on 8337.
This is on page 837, Your Honour, the paragraph immediately above the heading subsection B, substantive validity of international arbitration agreements. almost in the middle of the page, in contrast, the effect of the non-arbitrability provisions. And it might be worth there, for completeness and for your notes, Your Honours, just to cross-refer that to the New York Convention, which is in your authorities bundle behind tab 5 at page 113. At tab 5, Your Honour, page 113. And the relevant article is Article 2, which starts at the bottom of the page in the left-hand column and works over to the top of the right-hand column. Each contracting state shall recognise an agreement in writing. So that, firstly, Your Honours, that's where the part of Article 12 of the DIFC law that requires an arbitration agreement to be in writing derives, under which the parties undertake to submit an arbitration all or any differences which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not, concerning a subject matter capable of settlement by arbitration. So that last clause of Article 2.1, which in my submission is relevant because before you even come to Article 2.3, which provides the court of a contracting state when seized of an action in respect of 2.3 of the New York Convention, Your Honour, on page 113. Yes, right. So the Article 13 of the DIFC arbitration law derives from Article 2.3 of the New York Convention, court of a contracting state, when seized of an action in a matter in respect to which the parties have made an agreement within the meaning of this article, shall at the request of one of the parties refer the parties to arbitration unless it finds said agreement is null and void, inoperative or incapable of being performed. And, Your Honour, what I was directing your attention to previously was that it's Article 2.1, which, before you even get to Article 2.3, says that it must concern a subject matter capable of settlement by arbitration, and then in between Article 2.2 further clarifies, and Your Honour, this perhaps comes back to your point about the distinction of definition and form, because Article 2.2 of the New York Convention makes references to the form of the arbitration agreement. And, Your Honours, if we pause there, what is significant in my submission about Article 2 of the New York Convention is you can see in the DIFC arbitration law, parts of Article 2 are found in Article 12, those that relate to definition and form, and Article 2.3 finds expression in Article 13, DIFC arbitration law. And in my submission, that's further support for the case that you must have regard to Article 12 when undertaking the consideration of whether or not to award a stay pursuant to an application under Article 13. And again, if one thinks back to Injazat, one of the arguments there was whether it was a valid arbitration agreement because it was contained in exchange of documents. Well, that is obviously an argument that takes place under Article 2.2 of the New York Convention, and therefore under Article 12 of the DIFC arbitration law. And what Justice Sir David Steele did in paragraph 40, which I directed to you too, is he undertook that analysis. He said, yes, it would be valid, both in terms of Article 12 of the DIFC arbitration law and, for what it's worth, Article 2.2 of the New York Convention. And therefore, had I had the jurisdiction, I would have awarded a stay under Article 13, which mirrors Article 2.3. So I simply draw your attention to that point, Your Honours, because that is another support in my submission for the idea that the reason the drafters made express reference to the schedules, and the reason why the schedules go to the definition of Article 12, is because you have to undertake that exercise together.
some of the basic concepts of necessary to interpret the rest of the law. I think that because there's a reference to then you have to give full force respect to Article 12.2 to every act, even when outside of the IFC.
Yes, Your Honour, that's precisely what we're saying. And to adopt Your Honour's language, you say correctly that Article 12 of the arbitration law contains New York Convention language which helps define the agreement for the purposes of the rest of the law. In my submission, it also helps define the arbitration agreement for the purposes of any consideration by this court of the enforceability or validity of that arbitration agreement. And that really is the central submission we're making. The mere fact that a party expresses an arbitration agreement to be seated other than the DIFC should not, where DIFC law applies, prevent the court from having regard to Article 12.2. And Your Honour, if I could develop that, the reason why perhaps this is a difficult case is because Mr. Gray doesn't say, and has never said, that the arbitration agreement is invalid per se. It's been conceded from the outset it is capable of being a valid and enforceable arbitration agreement consistent with the DIFC arbitration, because it could be consented to. Simply that on the facts of this case, it hasn't been, and therefore it's unenforceable against him. And in fact, if you turn to, sorry to jump Your Honours around, but I think it's a point worth making clear. If you turn to tab 8 of the volume 1 of the appeal bundle, this was Mr. Gray's skeleton argument for the application hearing, and you'll see on page 60 behind tab 8 halfway down the page, this whole subsection was entitled "The Arbitration Provision Contained in the Agreement," that's a reference to Mr. Gray's contract of employment, "cannot be enforced against him." The law is set out there. And on page 61 there are some references to the factual matrix which we say shows that there was no written agreement or submission to arbitration. And then if you turn to page 62, Your Honours, or rather, sorry, if you start at the very bottom of page 61, what we say at paragraph 27 is that Gibson Dunn's submission that Article 12 is inapplicable is misplaced, A, because Article 12 concerns the definition of an arbitration agreement for the purposes of the law, and that's the point that I've been making to Your Honours thus far this morning. Over the page at the top of 62, B, because if an agreement doesn't comply with Article 12.2, it is unenforceable. In other words, it doesn't meet the definition of the arbitration agreement. And then C, this gives rise to two possibilities. And C1, the arbitration agreement is incompatible with the arbitration law. And perhaps that is perhaps that's a better wording than invalid, because of this distinction of substantive invalidity and non-enforceability pursuant to non-arbitrability principles. What we're saying is, in these circumstances, the arbitration clause in the employment contract is incompatible, circumstances being that there's been no written agreement, but it's capable of being compatible, it's capable of being valid, it's just that it isn't here. And if we look at, if we return to the points that are relied upon in Mr. Bourne's book by Gibson Dunn, so these are, so the extract that I have given you now ends, and if you turn to page 453 in your authorities bundle, Gibson Dunn's insertion starts at page 838. So we've gone through the 5 pages that lead up to his discussion of the principles under the New York Convention. And Your Honours, if you have before you page 838, he introduces subsection 1 of the New York Convention, and then reference is made at subsection A to the generally applicable contract law defences, and these are the defences which go to the substantive validity, and what is said is that these are generally on internationally recognised contractual principles rather than by intervention of domestic courts on the subject of what they may or may not deem to be non-arbitrable. If you turn over the page to page 839, one point that I would raise is right at the top of 839. So 839 of Bourne, it's page 454, Your Honour. I do apologise, I was looking at the Bourne page reference, 454 in your authorities bundle. What Mr. Bourne notes in passing is that Article 2 was added to the Convention in the closing days of negotiations. Little drafting attention was given to the article or its provisions concerning.
Where are you referring?
At the very top of page 454 of the authorities bundle, Your Honour. And I simply draw this to Your Honour's attention that what Mr. Bourne observes is that little attention was given to the provisions concerning the validity of arbitration agreements. And if you come down to the third paragraph on that page 454, which starts at the same time Article 2.3's exceptions, so just for clarity, Article 2.3's exceptions are null and void, inoperative or incapable of being performed. And you'll notice there that what Mr. Bourne says is that these are broadly drafted and capable of encompassing a substantial range of contractual defences. So they're not as narrow as is maybe being contended on their behalf. And importantly, if I can just draw Your Honour's attentions to the footnote 1114, which is in the middle of that page. So this is the footnote to the sentence: at the same time, Article 2.3's exceptions to the presumptive validity of an international arbitration agreement are broadly drafted and capable of encompassing a substantial range of contractual defences. If one comes down the page to that footnote 114, for example, as discussed below, defences based upon fraud, mistake, duress, unconscionability, legality, waiver and termination are all permitted by the New York and other conventions, see 506B and following. Now, the reason in my submission why that is relevant, because where Gibson Dunn's extract ends on page 459 of your authorities bundle, you'll see at the top of the page there he's discussing incapable of being performed. Subsection 2 then deals with European and inter-American conventions. And then a new subsection begins: invalidity of international arbitration agreements under national arbitration legislation. This is a subsection that's being referred to in that footnote. And that's where the extract that Gibson Dunn have given you ends. And so what we have asked to do is insert the pages that follow, because in the list of Mr. Bourne's examples of the grounds for challenging the validity of an international arbitration agreement under national legal system is, in black and white, employment disputes and consumer disputes. Not controversial if one takes Mr. Bourne's analysis that employment disputes and consumer disputes, as provided for in Article 12.2 of the DIFC arbitration law, fall within the list of recognised areas where there will be exceptions to the presumptive validity. And that gives rise to two submissions that I make on behalf of Mr. Gray. The first is that when it is understood that that is uncontroversial, the requirement to have regard to Article 12 when considering whether to order stay under Article 13 becomes much clearer. But the second submission that I'd make on behalf of Mr. Gray is that actually, because employment disputes and consumer contracts are capable of being within the bases under which national legal systems will challenge the validity of an international arbitration agreement, they fall back within the Article 2.3 of the Convention, the Article 13 of the DIFC employment law, categories of potentially being null and void, inoperative or incapable of being performed. And if you're still on, Your Honours, page 459 of the bundle, I'd ask you to turn back to page 456. 456, you'll see it's subsection C in the middle of that page, reference to null and void. So under C, Gary Bourne talks about the examples of when an arbitration agreement might be null and void. Again, I should stress this is for the purposes of the New York Convention, but the language is the same for Article 13 of the DIFC arbitration law. And we don't say that this agreement falls under any of those examples, but if you turn to page 457, this is where Mr. Bourne then goes on to develop examples of where an agreement might be inoperative. The middle of the page there, it also appears reasonably clear that Article 2.3, which permits the non-enforcement. So again, I just pause there, Your Honours, to re-emphasise that this is all about enforcement. And what Article 13 of the DIFC arbitration law permits is non-enforcement. So it's reasonably clear that where it permits non-enforcement of inoperative agreement, that refers to agreements that were at one time valid, but which thereafter have ceased to have effect or ceased to be operative. Now, in my submission, that is where we are now. This agreement is capable of being valid. It was at one time valid. And I'd go further. It's capable of being valid again in the future. But on these facts, in this instance, it is invalid. And you'll see that Mr. Bourne then develops that, says in one commentator's words, the word inoperative refers to an arbitration agreement which has ceased to have effect. That would include cases of waiver, revocation of repudiation, or termination of an arbitration agreement, or failure to comply with jurisdictional time limits prescribed by the arbitration agreement. Now, I make 2 points there. The reference to waiver is potentially significant because, of course, one of the things that Mr. Gray also says in this appeal is that Gibson Dunn has consented to him bringing the court proceedings that they are now trying to stay. And Your Honours, you may recall that it was submitted in the skeleton argument for the application that the application brought by Gibson Dunn was potentially an abuse of process, because the background matrix to this application was that Mr. Gray sought to amend his claim form in the DIFC. The amendment to his claim form was to bring his substantive claim in the court of first instance, and that amendment was consented to by Gibson Dunn. Hearing before a judicial officer, and following that hearing, it was confirmed that by agreement, Mr. Gray's claim form was amended. So Gibson Dunn come before you today asking for a stay in proceedings which they have previously consented to running. So the reference to waiver there is potentially relevant in my submission, because arguably on that basis it could be said that Gibson Dunn have waived their right to rely on this arbitration agreement. For completeness of the reference, though I'm not going to necessarily make any substantive submissions on it, the subsection, so in your loose leafs that we've handed up, you should have page 844 and then 845. And what you have at 844 and 845 and 846 is the introduction to Mr. Bourne's list of grounds on which the validity of an international commercial arbitration agreement will be raised. And at the bottom of page 145, loose leaf, sorry, Your Honour. So 844 is both the last page that Gibson Dunn provided and the first page that we've provided on this next set of loose leaf. And it's the start of subsection 5.06c. And you get one sentence at the bottom of page 844, and then you turn over, Your Honour, to 845. At the bottom paragraph on 845, Mr. Bourne lists the most frequently encountered objections to the substantive validity are A, fraudulent inducement, B, mistake, C, lack of consideration, D, unconscionability, and that list continues over to page 846. And what he then proceeds to do is he inserts a subsection that deals with each of those commonly encountered objections. So you can see what happens on 846 is he's about to launch into a discussion, or indeed he launches into a discussion of fraudulent inducement of fraud. Now, what we haven't done for the sake of the forests is give you the full list of all of those grounds, because obviously they're not all relevant. But what you next have in the loose leafs should be an individual page, page 894. It should still it should have been behind that in the clear plastic folder. It's just a single page because it's the only one that's relevant. So it doesn't contain a staple.
Page number?
894 at the bottom in the middle, Your Honour. Do you have?
Yep.
I separated out the pages, places where you told us to put them.
You're right. If you don't have it to hand, I'm very happy to hand up my copy, as it is just an individual.
845, 846.
After 846, there should have been an individual sheet, page 894. I apologise. You're very welcome to insert mine, because it is all I'm simply doing is drawing your attention to subsection 10. Subsection 10, still under, if you see at the top of the page, 5.06.c. So this is the 10th category of grounds under which the presumptive validity of an international arbitration agreement will be raised, and it's consumer and employment contracts. We've already been over the arguments as to why that is, but that's simply to draw your attention to the fact that to the extent that you find Mr. Bourne's commentary to be helpful, this is not a controversial proposition. This is not something which is exceptional. It is quite ordinary that national courts apply varying limits on the arbitrability of certain types of dispute, and employment and consumer contracts are among those. where does that take us, Your Honour? In my submission, there are two important things to grasp from that. The first is that you're clearly able to have regard to Article 12 of the DIFC arbitration law because it's expressly provided for through the schedules. And B, in my submission, you should have regard to Article 12 of the DIFC arbitration law because the DIFC has elected to place limits on the arbitrability of consumer contracts and employment contracts. And it cannot be right that a party can simply insert a foreign seated arbitration clause and say, OK, that allows us now to ignore the protections that this jurisdiction has agreed to insert. So this is not an agreement which is invalid per se, but it is an agreement which, by reference to Mr. Bourne's substantive invalidity points, is, in my submission, inoperative. But more importantly, and in my submission prior to getting to that discussion, it is an agreement which is not enforceable against Mr. Gray. It's not enforceable because of the DIFC arbitration law. I want to address you briefly. I'm looking at the time, Your Honours, and so I appreciate I don't have much more time. I think it is worth addressing you briefly on which law applies to the arbitration agreement, because there's potentially, again, been some confusion between the parties as to whether concessions were or weren't made. It is our case that the law which applies to Mr. Gray's contract of employment is DIFC employment law. It's our case that the law which applies to the arbitration agreement in Mr. Gray's letter of employment is DIFC arbitration law. And it's our case that the substantive law of the dispute, which I think is conceded by Gibson Dunn, would also be DIFC employment law. Now, what is said by Gibson Dunn, in my submission incorrectly, is that the law of the arbitration agreement in the letter agreement is the law of the state of California. And I'd like to briefly show you why, in my submission, that is incorrect. And that will require, I'm afraid, reference to the employment contract itself, which is found in Volume 2 of the Appeal Bundle at tab 10. It is perhaps right that we should, at this stage, finally look at the agreement that we're arguing about. Starting on page 158, Your Honours, behind tab 10. The letter agreement dated the 26th of April 2012.
What's the page number again?
Beg your pardon, Your Honour?
Page number. Page number.
Page number 157, Your Honour. 158, I beg your pardon.
And tag 11, not 10.
Oh, I beg your pardon, Your Honour. I thought it was at tab 10. My tabs may be out. Now, this is, I don't think it's an issue. This is a pro forma letter agreement. And again, potentially many of the issues in this case arise because this is clearly designed to be given to employees of the respondent all over the world, and it's been drafted to try and stay within the bounds of the various jurisdictions in which the respondent operates. And if you turn forward to page 164, have at the bottom of page 164 clause 13. I'll refer to it as clause 13, even though that's not how it describes itself, because otherwise we have a plethora of Article 13. So clause 13 of the letter agreement is the dispute resolution provision, and of course it was accepted by the judge in the application that it is a tiered dispute resolution provision, and that finding is not challenged on cross-appeal. And the relevant arbitration clause is at page 166, and it's subsection E, and it's headed third step, binding arbitration. Now, an important thing to note about the letter agreement is that it predates the amendment to the employment law, which inserted Article 4 of the DIFC employment law. And Article 4 of the DIFC employment law provides that if it's a DIFC employment contract, DIFC employment law applies. So if you briefly, Your Honours, turn to page 168, Clause 17 of the letter agreement governing law, this agreement is to be performed in and will be governed by the laws of the state of California, that is ousted by the DIFC employment law. And I think, again, I won't anticipate what my learned friend has to say, but I think that was what was conceded at the hearing below. Although it's stated to be California law, the DIFC employment law operates automatically to oust that. So the law that governs this employment contract is the DIFC employment law. Turn back to the arbitration.
Which provision of the employment law? We haven't looked at the employment law.
Your Honour, if you turn to the tab, so if you go back to the authorities bundle, Your Honour. Behind tab 2, at page 37 of the authorities bundle. And, Your Honour, the reason why I directed you to this version, which you'll see is the version which shows the amendments that were introduced by the amendment law, is because you can see on page 37, Article 4 of the employment law, as amended, has had Article 4.2 inserted. So prior to the amendment, there was no provision of DIFC employment law which said if it's a DIFC employment contract, this law applies. And that's what happens with the amendments. So it's the DIFC saying where it's a, we're not going to entertain the fiction that you can have a contract which is a DIFC employment contract and pretend it's not. If it's a contract of employment of an employee based within or who ordinarily works within or from the DIFC, this is the applicable law to that contract. So,
what date?
The law, I understand, Your Honour, took effect from December 2012. I think that was, I'm just going to turn my back to Your Honour for a second to take instruction. We think it was the 23rd of December 2012, Your Honour.
How does that operate in relation to contracts of employment?
Well, Your Honour, we say it operates on them effectively. And there's
From that moment onwards? From
that moment onwards, yeah. And in the interpretation law of the DIFC, reference to any DIFC law is to the law at that time in force. So there's no requirement for every company to go back and redraft all its agreements. It's simply the case that following the enactment of the amendment, DIFC employment law applies. And as I say, I think that was what was, certainly that was what we understood to have been conceded at the application hearing. Now, why that is relevant, Your Honours, is because if you look back at, and I apologise for jumping you through the bundles, if you look back at the employment contract in Volume 2, the arbitration clause at Clause 13E, which is on page 166, is, of course, right that the default seat of an arbitration under that clause will be California.
By which clause?
Clause 13E, which this is the arbitration clause in the letter in the employment contract, Your Honour, in Volume 2 at page 166.
13E?
13E, page 166. It's headed third step, binding arbitration.
Where do we see California law?
We don't, Your Honour. That is precisely my point. We see California as a default location for an arbitration absent agreement, and of course that is normally sufficient to say that that will be the seat of an arbitration absent agreement, and there is a presumption that absent any express terms to the contrary, the governing law of an arbitration agreement will be the law of the seat. But, Your Honours, if you come...
Right, sorry, say that last sentence again.
Well, if this clause was silent on the law governing the arbitration clause, then I think what my learned friend would say is the seat is California, therefore an analysis of this clause should be under California law.
Why? Distinction between the applicable law of the seat,
yes, Your Honour,
arbitration, which is the lex arbitrae. Law governing the arbitration agreement is a separate exercise.
Precisely, Your Honour. And
I thought you said if it says the seat is Californian, then we interpret this clause according to Californian law.
Well, Your Honour, sorry, I'm making the mistake of trying to make the arguments against me before they've been made. My point is that by reference to to Clause 13E, and if you come, and I appreciate the typing is quite dense, so you have to come about halfway, 2/3 of the way down. 1, 2, 3, 4, 5, 6.
New York law?
Well, if you're at New York law, then that's very helpful, Your Honour, because what's said there is the substantive law governing the question in the claim shall apply, e.g. New York law with respect to claims under New York law, federal law with respect to claims under federal law. Now, in my submission, that indicates the parties' agreement that the law which applies to the clause is the substantive law which applies to the dispute. And it is accepted in this case.
Governing law, you mean?
The governing law.
And this contract doesn't have a governing law?
It has a governing law clause of California that is ousted because it is a DIFC employment
I'm
contract.
not sure, but where do you say, which is the clause that you say has been ousted?
Well, Clause 17 on page 168, Your Honour.
How does any of this matter at all? Because in the context of Article 7 of the Arbitration Law Amendment Law, we're looking at either Article 7.2 or Article 7.3, which applies where no seat is designated or determined. And that's the position here, isn't it? That there's no seat actually designated or determined.
Yes, Your Honour. That was the finding. But I don't think I can sensibly make the submission that the arbitration clause in Mr. Gray's employment contract doesn't have a fallback where the seat absent agreement would be California. So what I can't make.
But it's a no designated seat with a fallback provision
in this
if
instance,
the parties can't agree.
In this instance, yes, Your Honour.
So how does the governing law question matter at all in the context of the argument about Article 12.2 and Article...
Well, simply to the point, Your Honour, that we would say the DIFC laws are the relevant laws when analysing that contract. And I only raise that point because it said in my learned friend's supplementary skeleton that the law that you should apply to analysis of the arbitration clause is California law, and we simply say that's wrong.
How it matters.
It was a point I wanted to make. Your Honour, I'm looking at the time, and I've definitely run out of my time. Summarise effectively what we say, and what I would do, Your Honours, if I may, is commend my supplementary skeleton argument, which I appreciate you hadn't had to you. That will really make the points in summary that I want to make now.
Just confirm that in this oral presentation today, you have not raised any point which is not to be found in original or supplementary skeletons.
Your Honour, no, I think save that we've referred to those parts of Mr. Bourne's text which were not previously. This is a development.
Apart from Gary Bourne, yes, thank you.
Grateful, Your Honour.
Yes, Mr. Lovett.
Thank you, Your Honour.
Before you start, let's just one quick question, Mr. I mean, if you complain that the judge hasn't applied his mind to provision that creates the exception to the prohibition, which is if this court decides that place application of the employment law or the prohibition in the arbitration law, would that not cut across all of your objections in this case?
Sorry, it cut across the objections how?
Well, your main complaint in your original grounds of appeal, as I saw it, was that the learned judge below didn't consider whether or not the displacement exercise had been considered by him. So he didn't displace. If he didn't displace, then all of your arguments are based on the substantive effect of the provision. Arbitration law that say employment contracts are not enforced can't go to arbitration without the consent of the employee. But there is this final condition that allows the court effectively to permit the case to carry on to arbitration subject to those considerations. So if we now decide that those applications have force and we decide now to displace application of the earlier provisions, would that not cut across every one of your arguments?
Well, Your Honour, if I can very briefly...
And you haven't addressed us on that at all.
Very briefly, those provisions are Article 2, Roman numeral 1, 2 and 3. Roman numeral 1 says where a party is given written consent after the dispute in question has arisen, and what we say is that on the evidence that was available before the learned judge, it simply wasn't open to him to find that written consent had been given, and that doesn't seem to have been extensively analysed one way or other in the judgment. In respect of Roman numeral 2, where a party has submitted to arbitration proceedings commended under the arbitration agreement, there are no arbitration proceedings in play, so that doesn't arise. And in respect of Article 12.2, Roman 3, I make no reference to it because no reliance is placed or has ever been placed on that by Gibson Dunn. So if you go back to Gibson Dunn's original application for the stay, they did say in the application, for the sake of completeness, because we anticipate that what Mr. Gray will say is Article 12 applies, A, we say it doesn't, but B, in any event, we say have a look at Article 12.2, Roman numerals 1 and 2, but they don't anywhere say, we also rely on the discretion of the DIFC at Roman numeral 3 in Article 12.2. So that isn't in play at all, and in respect of those first two, has written consent been given? We say it's not clear that the judge found there had been written consent, but to the extent he did, that finding simply wasn't open to him because the evidence...
We have the power, do we not, at this stage, to look at paragraph 3, if we think it appropriate.
But as a pleading point, Your Honour...
I have seen some arguments about substantive provisions of this.
There is an argument running through the submissions on behalf of Mr. Gray and countered by Gibson Dunn that one of the reasons why he thinks this should proceed in the DIFC courts is that it is more substantially fair to him, and there are reasons about convenience. And there is a live argument, I think is right, between the parties as to the extent to which various concessions over potential arbitration seats and procedures have or haven't been offered. But in my submission, where the applicant, the respondent in this appeal, has not made the application which we're appealing against on that ground, in my respectful submission, that this court shouldn't then say, well, hang on, let's have a look at Article 12.2, Roman 3, and think whether this falls under that head. Because, of course, if the application had been made on that basis, then Mr. Gray would have prepared to resist the application differently, and he maybe would have prepared this appeal differently. But the preparation for the resistance of the application was on the basis that, well, they've raised Article 12.2 Roman 1, and so we set out in evidence before the learned judge why written consent wasn't given. And in any event, we say further why there was agreement between...
Interested in the 1 and 2. I'm not really interested in 3.
Yes, right. Well, I mean,
I think that we cannot now make an order under 3. That's what I want to know your position.
My primary position, Your Honour, is that you can't, because the original application wasn't brought under that head. It simply isn't pleaded.
One of the grounds of appeal was that he didn't consider that particular section.
But the ground of appeal was that he didn't consider Article 12.2 in respect of Mr. Gray's objections. It would have been open to Gibson Dunn to cross-appeal by reference to our argument that that wasn't considered and say, well, if that's right, then we would also invite the court to, if it's going to have a look at Article 12 in total, to look at Article 12.2 Roman 3. But that wasn't done. So my primary submission is it's not in play, and it would be unfair to expect Mr. Gray to canvass extensive argument on that point when he would have had no basis for thinking it arises. For completeness, if I'm wrong about that, Your Honour, and for Your Honour's benefits, we don't say, or rather we do say, that Article 12.2 Roman 3, we say that should not be applied. It's self-evidently going to be detrimental to Mr. Gray to be forced to arbitrate other than in the DIFC. The DIFC is the appropriate forum, the DIFC courts are the appropriate forum for the resolution of a dispute which is under a DIFC employment contract, and which, as I mentioned in my skeleton arguments, and you'll have seen in submissions, one of the key points in the substantive dispute it is by reference to unique provisions of DIFC employment law. So this is appropriate in that respect. There's also the live issue of witnesses, and Mr. Gray says that in the substantive hearing he will wish to call witnesses who are largely based in Dubai and working and are resident in the DIFC, and that the powers of the DIFC courts in respect of those witnesses are greater and more appropriate in this circumstance than would be the powers of an arbitral tribunal. Yes, Your Honour. It is.
For us to take a view on should we...
I can't, Your Honour, I can't prevent you from taking a view, but I do repeat my submission that in circumstances in which this hasn't been raised by Gibson Dunn, it wasn't a basis for the original application, I would urge you not to do that.
Yeah, Mr. Lovett, and then we'll come back to it maybe. Yes, Mr. Lovett.
Sir, thank you. If I could start by just clarifying or setting out Gibson Dunn's position on this question of the concession of the governing law. The position is this, and I apologise, my friend's slightly confused by it, but the position is this, is that we concede that the DIFC employment law can or will apply to certain elements of Mr. Gray's underlying claim, and those elements ostensibly relate to payments that Mr. Gray says are due to him pursuant to the law, namely payments for his end-of-service gratuity, payments for health and insurance, and a penalty payment, a payment for his final dues, if you like, his the final calculation of what is owed to him in terms of expenses. And then he's also making a claim under what I would now deem the sort of infamous article of the employment law, which is, I think, Article 18, which applies a penalty on a daily rate for every day that the employer fails to pay, 18.2. So those are the DIFC employment law claims that Mr. Gray is making, but on Mr. Gray's own evidence in his witness statement, he says that California law also applies to the dispute, because the largest part of this dispute, although monetarily particularly having regard to the alleged liability under 18.2, which of course Gibson Dunn denies, but monetarily, the larger part of his claim, and in terms of the complexity, the more complex part of his claim relates to the circumstances surrounding his dismissal and his request or his claim that Gibson Dunn honour the indemnity that he says he is entitled to in terms of his legal costs for pursuing his appeal against the findings of Mr. Justice Flo, as he then was, in the English High Court. But by far and away the meat of this case and the issues that need to be determined and the witness evidence is going to be by far and away in relation to the claim for unfair dismissal and in relation to his claim for an indemnity for his costs. And those claims are governed by the laws of the state of California. But we do concede, and we have conceded, that there are certain elements, as I've noted, that relate or are governed by DIFC employment law. And in fact, the arbitration agreement, my friend took it to you earlier, I'm not sure I need to do the same, but the arbitration agreement makes it clear that although the arbitration agreement itself, we say, is governed by the laws of the state of California, the agreement, we're not saying that that has been superseded or set aside. We haven't agreed that at all. The arbitration agreement is governed by the state, the laws of the state of California. My friend has agreed or conceded that the seat of the arbitration is California, or there's a fallback provision for the seat of the arbitration to be California. But the terms of the arbitration agreement per se enable the parties to determine their substantive disputes in accordance with the contract that governs them. And the example, it's just given by way of example in the arbitration agreement, that, for example, the laws of New York, if they're the substantive laws that govern the dispute, then the JAMS arbitrator will apply the laws of New York. And that's uncontroversial in my submission. That's straightforward. It's common sense. The laws that have been determined as the substantive laws for the underlying dispute will be applied. And in the court below, our submission was this, that the DIFC employment law is not a complicated or difficult piece of legislation to understand. It just needs applying by an arbitrator, having regard to the facts as he finds them, as they're presented to him by both parties. So the DIFC employment law is not a piece of wizardry in terms of its content. It's very easy to understand, but our point and our position, our short position on this, is that by far and away the greatest dispute relates to issues that are governed by the laws of California. And although my friend says that that has been a concession and that this appears to be his case, that every part of the dispute is governed by DIFC law, that's not the case, and that's not what Mr. Gray says in his witness statement. And I can take you to his witness statement, or I'll give you the citation if you like. It's in volume 2 of the hearing bundle at page 196. So it's paragraph 80. This was a statement made on the 28th of May 2016. The tribunal would have to apply DIFC law as well as Californian law. And the debate between the parties, I think, was a short debate. I think it was initially asserted by Gibson Dunn that California law applies to the entirety of the dispute, but it has been conceded. It was conceded at and indeed before the hearing below that certain elements will involve DIFC employment law. If I could just briefly, I get the sense that the nub of this dispute is essentially the applicability of Article 12 and Article 13, and my friend says, probably correctly, that this court hasn't had, or any court, whether this court or the court below, hasn't actually grappled with the interaction between Article 12 and 13 as they relate to the to Article 7 of the arbitration law and the interplay between them. But in a sense, that's true insofar as Article 12 applies. But the court below, certainly in the Injazat case and the electromechanical case, have looked at the provisions of Article 13. And I'm not sure you want me to take you to those cases, but the court has looked at Article 13 in terms of the previous arbitration law and whether or not
2004.
2004, yes, so it was 2004, and whether or not Article 13 applied to a foreign arbitration agreement or whether it applied to a domestic arbitration agreement. There was some uncertainty in both of those cases, and the court tried to overcome, it's certainly in the electromechanical case, the court, in my respectful submission, tried to overcome the difficulties it then faced in relation to Article 13 by saying, well, although Article 13 doesn't apply in that case because Article 7, which is the scope and applicability section of the arbitration law, did not refer to Article 13 as then being within its remit, the court decided that it had an inherent jurisdiction to stay proceedings in favour of an arbitration agreement. And there are a number of reasons that the judge set out in explaining why he felt he had that inherent jurisdiction, and one of those reasons was to comply with the provisions of the New York Convention. Now, it's notable in our submission that after those two cases were decided, the arbitration law was then amended, and I'd just like to take you briefly to the amendment law. Whereas my friend took you, took you firstly to the DFC employment law. I won't ask you to turn it up, but he took you firstly to DFC employment law, which incorporated some fairly significant changes to the previous law, although there were some changes, and in particular the law that related to unfair dismissal, because there hasn't been one, and neither did the later consolidated version of the employment law introduce one. But the employment law was fairly heavily amended to reflect some changes in approach. Now, if I could ask you to turn to tab 4 of the authorities bundle. And although we have the current version of the arbitration law in tab 3, we don't have the full version of the previous law, and the simple reason for that is because there was only a very, very small amendment, a very slight amendment to the previous arbitration law, which in my submission was brought about precisely because of the difficulty that the court raised in both the Injazat case and the electromechanical case, which I've also I can also take you to in the authorities bundle. But I draw your attention to this. My friend says, well, you should read Article 12. You can't read the law and you can't divorce Article 12 from Article 13. Article 12 exists in the law, therefore you have to give it some meaning. You have to ascribe some meaning to it. And because it's there, you ought to apply the provisions of Article 12 in preference to those of Article 13. That seems to be the substance of his argument. But if you have a look at page 111 of the authorities bundle, which is headed Scope of Application of Law, then there have been some very small, but in my submission very, very significant amendments. And the first one is to delete the reference to parts 1 to 4 and the schedule of this law which previously said parts 1 to 4 in the schedule of this law shall apply where the seat of the arbitration is the DIFC. And then it says, and then that's been changed to subject that paragraph to the provisions of subparagraphs 2 and 3 following. So the impact of this, we would say, is that it's a very clear direction to the court as to which bits of the arbitration law apply to domestic arbitrations, i.e. where the seat of the arbitration is in the DIFC, and arbitrations which are foreign or international arbitrations where the seat is one other than the DIFC. And one of the problems that the court grappled with in those two previous cases was that Article 13 was not mentioned in the context of a foreign seated arbitration. And the effect of the amendment was to bring Article 13 fairly and squarely within the exception to the scope and application of the arbitration law. So, in my submission, it's these articles and these provisions, when it talks about the application of the law, it gives rise to an obligation on the court to look at these sections and these articles separately. And there is no scope or no room to read them together or to incorporate or imply one article into another. Now, my friend, the only way he could really deal with or bring in the scope of Article 12, having regard to the amendment that you see in front of you, the only way that my friend could argue, and has argued consistently, that Article 12 does apply is because there is a definition in Article 12 that relates to an arbitration agreement. But if I could then take you to Article 12 of the new arbitration law, which is in the previous tab at page 89 of your bundle. This section is headed Definition and Form of Arbitration Agreement. So it does deal with definitions, which we say, and I think this was alluded to by His Honour Mr. Justice Cooke. The first part is the definition of arbitration agreement, and one has to read that in conjunction with the definition of arbitration, which you can find on page 108. And it's rather circular because it says an arbitration is defined as an arbitration for the resolution of disputes conducted pursuant to an arbitration agreement as defined at Article 12 of this law. Then Article 12 talks about an arbitration agreement, an agreement by the parties to submit to arbitration, and that's capitalised, and when you look at arbitration it then refers back to an arbitration agreement. But the point is that we say an arbitration agreement is simply defined in Section 12, and that doesn't mean to say that you have to have regard to the entirety of the section when interpreting the provisions and the scope and applicability of the law as set out by Article 7. And my friend raised the sort of hypothetical example of an arbitration agreement not being in writing. He said, well, it's not possible not to have regard to other provisions of Article 12 because Article 12 also provides that arbitration agreements must be in writing. But if the substantive law of the agreement is one other than DIFC law, then one doesn't really need to get into the detail of other provisions of Article 12 anyway. If the substantive law of the arbitration agreement, and indeed the seat of the arbitration, which my friend has agreed is California, then the arbitration agreement is governed by the laws of the state of California, as is the seat. And so one would look to the laws of California to see how it would be dealt with in circumstances where one party alleges that there's no valid arbitration agreement because it's not in writing. That's the sort of riposte, if you like, to my friend's suggestion that one has to look at other provisions of Article 12 when interpreting the arbitration law. So one
say that you might be interpreting it in the light of the convention as its own requirements in relation to arbitration.
Yes, indeed. Yes. It's subject, and I'm not suggesting for a minute that a valid arbitration agreement would be in anything other than in writing, but to take my friend's example, the way in which that would formally be decided is pursuant to the laws of the state of California, and the US, of course, is a party to the New York Convention, and that's the way it would work through. So we would say that... So Article 13, if I could just take you to Article 13 on page 91. If an action is brought before the DIFC court in a matter which is the subject of an arbitration agreement, well, we say that there is an arbitration agreement. One does have to look at Article 12 because Article 12 is headed definition and form of arbitration agreement, so there's nothing controversial there. We say, well, you look at the definition of arbitration agreement in Article 12, and it's an agreement by the parties to submit to arbitration all or certain disputes which have arisen or may arise between them in respect of a defined legal relationship. Now, my friend again concedes that they don't say that the arbitration agreement per se is a nullity, and this is an important point. It's not been alleged that the arbitration agreement is a nullity. And this is a theme that's run throughout, or has run throughout, the application below and this appeal, is that there's just simply a distinction between the existence of the arbitration agreement and its enforceability. Now, my friend has said, well, were it not for Article 12, it's agreed that this would otherwise be a valid and enforceable arbitration agreement. And the whole thrust of his argument, the whole thrust of the case below and on appeal is that Article 12 applies, so you should not enforce what is otherwise a valid arbitration agreement. But if it's accepted, which it has been, that this is a valid arbitration agreement, so it's a matter which is the subject of an arbitration agreement, the DIFC court shall, if a party so requests, not later when submitting its first statement on the substance of the dispute, dismiss or stay such application unless it finds that the arbitration agreement is null and void, inoperative or incapable of being performed. Now, again, those are words that my friend has taken you to. I won't do the same, but those words are taken fairly much verbatim from the New York Convention. Mr. Bourne's text, which I would like to take you through, gives examples of what a null and void, inoperative or incapable capable of being performed actually means. And in my submission, this isn't really an argument that's been run. The only way in which one could say it's been run is that it's incapable of being performed because Article 12 applies. But as a standalone basis, this argument, it hasn't been run, as far as I'm aware, and from what I've heard this morning, that on a standalone basis there are other grounds upon which it's said that the arbitration agreement is null and void, inoperative or incapable of being performed.
So, Mr. Lovett, would you please make it clear, like, in case of arbitration where they sit outside the DFC, and hypothetically, let's presume the applicable law, the local law, then validity is a question before this court. What I'm going to apply to check, to examine the invalidity of that arbitration if I disqualify Article 12?
Well, you can still, generally speaking, and again I can take you to some of the textbooks on this, but generally speaking, the principle of competence means that an arbitral tribunal is competent to rule on its jurisdiction. And if one of the parties says, well, this arbitration agreement is invalid, null and void, inoperative, incapable of being performed, then that is something that the tribunal itself can rule on. But that's the general rule, but that doesn't stop a domestic court from looking at the same points. And I think this point is covered in one of the texts. I can take you to it. But unless that's a controversial submission, in general, the tribunal will rule on its jurisdiction, having regard to those points if they're raised against an arbitration. But a domestic court can also do the same. And I think one of the commentators says, well, it's hoped that the arbitral tribunal would have some cognizance of what a domestic court has held, but they're not necessarily bound by it. Does that answer your question, Your Excellency?
Sort of. I see your point, yes, in this.
So, sorry, I was going to take you then to that section of Bourne. Which I've now... It's at tab 21. Oh, sorry, of the authorities bundle. And if I could ask you to have a look, please, at page 456. And so, if I could just take you to the section burden of proof. As also discussed above, the burden of proof of invalidity of any international arbitration agreement under Article 2 of the Convention is on the party resisting enforcement. And for present purposes, the enforcement would mean the validity of the arbitration agreement. And again, I don't think that's a controversial statement. That allocation of the burden of proof is mandated by both the text of Article 2.3 and by the Convention's rule of presumptive validity of international arbitration agreements and pro-enforcement objectives. In other words, the overriding objective of the treaty is to give effect to a valid arbitration agreement or arbitration agreements per se. Indeed, for the same reasons, the better view is that the party resisting enforcement of an international arbitration agreement bears a particularly weighty burden of demonstrating the invalidity of an agreement to which the parties have consented. And then one gets to the what I call the sort of three heads of invalidity, the null and void head. It appears reasonably clear that Article 2.3's null and void exception refers to cases in which an arbitration agreement was defective or invalid from the outset. And my friend very helpfully agreed that that wasn't the case that was being made here. And so there's no suggestion that it's invalid. In fact, the contrary is true. My friend has conceded that the arbitration agreement is valid, and the seat is California, but it shouldn't be enforced. And over the page on 457 of the authorities bundle, under the heading inoperative, the very last paragraph on the page before the long footnote, thus an arbitration agreement would be inoperative where the parties actively pursued litigation rather than arbitration, resulting in a waiver of the right to arbitrate under applicable law. Well, that hasn't happened here either, and my friend tried to get under the bar on that one, although I would submit that he's nowhere close to discharging the required burden. But my friend says, in effect, well, there was a waiver by Gibson Dunn at a small claims tribunal hearing of the arbitration agreement because there was some form of consent to Mr. Gray initiating proceedings in the court of first instance. Well, that's always been resisted. Firstly, that doesn't seem to me, as I understand it, to be a ground of appeal. Secondly, it wasn't a finding of the judge. The finding of the judge was that the arbitration agreement was valid, and my friend has conceded that. He hasn't made a case that any part of that agreement has in some way been waived. And thirdly, all he points to is an email from the judicial officer or the registrar in the small claims court, the small claims court, which, paraphrasing it, I think it is in the hearing bundle. I won't take you to it. It was in the original hearing bundle, but it says something to the effect, well, the parties have agreed that Mr. Gray can file his claim, sometime the following year. That is contested. It's always been contested. There was never any agreement, in spite of what the email from the judicial officer might have said. And in fact, the position of Gibson Dunn was consistently, and has been, that they are standing by the validity of the arbitration agreement, and that was the first communication, I think, that was sent by the firm once the small claims claim had been filed.
All right, just as a matter of fact, no arbitration has yet been commenced in California, is that correct?
Correct.
So no application has been made to JAMS?
No.
By either party?
No. So if I could, I will take you as part of my final submission to the arbitration agreement, just to set out how it works. But perhaps I can just deal with that before I take you to the document. But the way in which it works is that there is what we've called a waterfall. So under the heading of Section 13, Section 13 is simply headed arbitration. And then it says the parties agree to follow this process in the event of a dispute. There's been some mention of controversy. That's not a point. That's a point that my friend has covered in his skeleton and that's been dealt with by us. But my friend says, well, there's no controversy arising. There's no dispute, so there's no controversy to which Section 13 of the arbitration agreement can latch onto, because controversy excludes those disputes that are incapable of being arbitrated. And my friend, I think, has suggested, or he's submitted, that because of the effect of Article 12 is that this is an arbitration agreement that's incapable of being perfected or formed because of, I think the arbitration agreement, I can take you to it, talks about state law. So if state law prohibits arbitrations being agreed in relation to certain matters, then that is excluded from the definition of controversy, and therefore the provisions of Article 13 just fall away. But in my submission, that's just simply to deal with those jurisdictions where certain disputes have been legislated against as being non-arbitrable. My friend is...
Back to the same argument about 12.2 and 13. Exactly.
Well, yes and no, and in fairness to my friend, the applicability of Clause 13, I don't want to confuse Article 13 of the arbitration law and Clause 13 of the agreement to arbitrate in the employment contract. But the arbitration agreement is predicated on a controversy existing between the parties. And my friend says that the arbitration agreement hasn't kicked in, and therefore there's no obligation to arbitrate because there's no controversy. We dealt with that in the court below. I'm not sure my friend currently stands on that, and it's not an argument that he forcefully put to you this morning. But we would say, well, it's not that an agreement to arbitrate employment disputes is unlawful per se in the DIFC. Two reasons, effectively. Article 12 says, well, those agreements are not enforceable in certain circumstances. And it's obvious that if one wasn't permitted to arbitrate a consumer or employment contract, then there would be no need for Article 12 at all, because you wouldn't have an arbitration or a dispute that entailed those types of contracts. So I can leave, if I may, I'll just leave that to one side.
When are you going to deal with this application of Article?
Yes. Well, we say, and it goes back to the interpretation point, and Article 7 of the arbitration law talks about scope and applicability of the law. So there's the law subject to Articles 7, 2 and 3. This law shall apply where the seat of the arbitration is in the DIFC. It talks about parts. I've turned over the section, but it talks about the sections that are applicable, which is a vast majority of the arbitration law, apply where the seat of the arbitration is in the DIFC. The key point is once you have an arbitration where the seat, or a potential arbitration where the seat is outside of the DIFC, and my friend has agreed this morning that the seat is California, although an arbitration hasn't been commenced by Mr. Gray, the parties are obliged, under the terms of the agreement, to discuss whether or not they can agree an alternative. And there was some evidence in the, before the court below as to whether or not there had been discussions that had taken place. And the evidence was that there were the two alternatives that had been put forward were London or Dubai, and Gibson Dunn has said and offered for an arbitration to take place in London. But under the terms of the arbitration agreement, the location of the arbitration and indeed the arbitral institution can be agreed between the parties. But there is a fallback, and it says in the event that no agreement can be reached, the arbitration will be held in California in accordance with the JAMS rules.
Gone through the tiers, the mediation?
Well, there is some dispute. There has certainly been some negotiation. There has been a mediation. We say that both limbs are precursors to the right to bring arbitration proceedings. Mr. Gray, I think it's fair to say to him, he disputes whether or not the mediation that took place in California and whether the negotiations that have taken place fell squarely within the provisions of the waterfall of Article 13. We say they do. He says they don't.
Well, in the arbitration stage, are you going to make an application, or have you made an application ask us to disapply Article 12? Or are you saying it's not necessary?
Well, again, in fairness to my friend, we've said all along it's not necessary because this arbitration is a foreign-seated arbitration. We've said that the provisions of Article 12 don't apply.
Right, so your primary argument is Article 7(1), that the whole of the arbitration law doesn't apply.
Well, no, the primary argument is 7(2).
Really, 7(3), because it was that the seat was designated. So all you've got is a fallback provision as to where.
Well,
either 7(3) or back 7(2).
yes,
And under 7(3), it's only Article 13 that applies without anything else.
Yes, yes, and in fact, in terms of clarification, and that's one of the clarification I think we made in the supplementary skeleton, because it was suggested that we were only relying on 7(3), and we said yes, well, we're relying on 7(3) and 7(2), because of the designation of the seat, and the designation of the seat, in that sense, and as the judge found it at first instance, as of today, as of this time, because we say Mr. Gray has breached his contractual obligation in terms of bringing arbitration proceedings, the fact that he's breached those and come straight to the court, and incidentally in breach of another provision of the agreement which waives his right to come to court to seek this type of relief, but because Mr. Gray has breached that, we haven't yet got to the stage where we're discussing or negotiating a potential for an alternative seat or an arbitration provider, which the arbitration agreement obliges us to do. But as Your Honour points out, the fallback position, if no agreement can be reached, would be Article 7(2). And
You
the
don't get to 7.2 or 7.3 unless you apply 7.1 first. Not have a seat, that's what you're saying. Seat is not in the DIFC unless by agreement. There has not yet been. So as of this moment, all of the arbitration law doesn't apply.
Well, no, there has been
Is that your case?
No, there has, with respect, Chief Justice, there has been an agreement, and the agreement, the seat of the agreement is not DIFC. There is an agreement that the seat of the arbitration is California.
Yes, if it's in California, then it's not in the DIFC. If
Yes.
it's not in the DIFC, this law doesn't apply. Correct?
Correct. Correct. So,
That's the starting point, and because of that, you say then we don't have to worry about the disapplication.
well, yes, correct. And that's what we've argued. We've said because the seat is a foreign seat, one just has to look at the provisions of Articles 7.2 or 3, and under 7.2 we say, well, Article 13 is the article that applies. If an application is made, if proceedings are brought before this court in breach of an agreement to arbitrate, we say we have a right under Article 13 to have those proceedings dismissed or stayed, unless the court finds that the arbitration agreement is null and void, inoperative or incapable of being performed. And in our submission, A, that's not seriously been argued, and B, it doesn't really fall within any of the definitions that I've just taken, or any of the examples I've just taken you through in Mr. Bourne's text.
Employment law as such, I want to see what the provisions of DIFC employment law, how do they apply to Mr. Gray?
Well, the employment law is set out. The employment law amendment law is at tab 2.
No, the law itself, because that's where the definition of who it applies to will be, unless you say it's also in the amendment law.
Sorry, that's where. Sorry,
Why does the employment law apply to Mr. Gray?
Well, he is an employee. He was a salary partner at Gibson Dunn. He wasn't.
But Gibson Dunn in Dubai
Yes.
is a branch of Gibson Dunn in California. I don't know. I mean, I'm looking at the agreement. I assume that the LLP in Dubai is in the DIFC is the same as the signed the agreement with.
Correct.
So, I mean, it's a foreign contract of employment with the employee being seconded to work in one of the offices. Is that the position?
Well, he has a contract. He has a contract of employment, and the DIFC law says that it imposes certain minimum standards.
Can I have a look at the
Yes.
DIFC law that says that, please?
Yes. Well, the DIFC law is at page 37, so it's at tab 2 of the authorities bundle.
Back to.
So it says the purpose of the law is to provide minimum employment standards to employees based within or who ordinarily works within or from the DIFC.
4 is the one that we should be looking at. Dunn doesn't come under 4.1a, under 4.1b.
But it's an establishment having a place of business in the DIFC.
Establishment only applies to government.
Well, it's not under the law. It's not a defined term.
Under the DIFC law, isn't it?
Yes, DIFC law, yes.
In our jurisdiction, founding charters, I seem to remember.
Well,
Establishment is defined as a government.
Barclays case.
Well, I think it's wider than that. I think establishment means it has a place of business in the DIFC.
That's a separate one about being registered. But
Yes.
establishments, I think, are government entities. So unless you are under law number 9 of 2004. Have this problem in other countries where people sign up with the head office and then down, and then they still want to be employed by the head office, so they maintain their contractual relations with the office and not get seconded to a local subsidiary.
Well, I think. I mean, my experience in the DIFC is that very often, for secondees in particular, they would have, or very often they have two employment contracts. They have their home contract, and then they have their DIFC contract.
Then there's a relationship between the two, and then they want their pension rights and all that under the main contract.
And there is a relationship between
anyway,
the two. Yeah.
You know,
But I think the short point is that we've conceded
that the employment law applies to Mr.
in the respects in which it's being alleged apply. We say yes, they apply to Mr. Gray because
at first blush, Article 12 would apply unless you invoke one, which is that this arbitration IFC,
correct,
unless you make a concession.
Correct.
Apparently, you may that it had been discussed, the possibility of seating.
Well, we have discussions have taken place. In a way, this is the cart has been put before the horse because the obligation to have that discussion doesn't start until Mr. Gray files an arbitration in California, and then the parties have got a period of time in which they can decide that the seat of the arbitration and or the location of the arbitration in terms of having the hearings. We could still keep the seat in California, of course, and have the location in London. Or
I was just going to say I didn't notice anything that understood the distinction. Because all the arguments are raised about the evidence he needs to assemble being in this part of the world.
yes, well, that's what Mr. Gray says. But we also say that a large part of the underlying dispute took place in London. The trial the trial which is subject of the main part of this dispute.
That, there are two different issues.
Yes. I mean, Mr. Gray is a non-practicing barrister and a litigation partner in a prestigious law firm. If Mr. Gray doesn't understand the difference between... If Mr. Gray didn't understand that distinction, then I'm not sure there's much hope for anybody.
Carry on, please, Mr.
Well, I'm not sure. I was going to take you... I was going to take you to the Ingersat and electromechanical cases. I'm not sure I really need to do that because they were...
Their history now.
Their history. It was an explanation and a precursor to the amendment to the arbitration law, which I don't think I need to take you to.
Let's have another look at the arbitration amendment law.
Tab 4.
Oh, this is selected. Is this the entire
This is the entire amendment.
amendment?
This is it. Which in my submission reinforces the point that having been brought in after the Ingersat and electromechanical cases, this law was very definitely designed to deal with a defect which had come out in those cases, which related to the applicability of Article 13.
What we can't see from this document is there apparently are minor amendments to the text of the arbitration law, which
I'm not sure I've seen those, Chief Justice.
what happens in this amendment? It repeals 2004 law completely, and based in its entirety by the law, which is this law, and this law in itself can't sustain an entire arbitration regime. Must be an attachment to this law. I can tell you at least one other amendment, 2004, which is not provided for in the text of
Yeah, I mean, Article 5, Part 1 does say, you're right, as of the date specified, the enactment notice, DFC Order Number 8, should be repealed and placed in its entirety by the law.
As long as nothing turns on any other amendment to the law.
Well, I mean, this is the amendment law taken in its entirety from the DFC Court website. And in fact, I think rather confusingly, the old law is still on the website. The new law is just listed as the consolidated version, but under a different section of the website. So in other words, if you're looking for the most current version of the arbitration law, you kind of have to hunt around for it.
IFC Court's website.
Yes.
The IFC website.
The IFC website, where one finds the legislation. I think the amendment comes under, there's a specific box or section that lists laws that have been amended. But if you look at the section on applicable laws, I think I'm right in saying that the laws as they originally stood are set out there. Yes, in the context of waiver, well, I think I've dealt with the point my friend suggested that there'd been some concessions in terms of the applicability of DIFC law, and he was under the impression that we had conceded that the whole of the dispute governed by DIFC law. I trust that my explanation is a bit clearer, namely that we accept there are certain parts of DIFC employment law that an arbitral tribunal can apply, but a vast majority of the dispute is going to be governed by the laws of California. I don't think I need to. My friend touched on a question of abuse of process. He didn't elaborate on it, but referred to, in some way, to the meeting that took place with the Small Claims Tribunal. I think that's not really a point that's been pursued, but nevertheless, we would say that it may be seen as an abuse of process by Mr. Gray to have commenced a small claim seeking the validation of the arbitration agreement purely for purposes of his visa, but that's another thing. Agreement to arbitrate.
More to the point, came to the Small Claims Tribunal wanting to arbitrate and told the court that's what he wanted to do.
Well, yes, and that was the small point I was making, which is he wanted, and he said the only reason he was doing that was because he was told that he couldn't cancel his visa until he brought a claim. So he decided to bring a claim for a declaration that the arbitration agreement was valid. And then he changed his mind and amended the claim to bring the current claim. So, well, he says we agreed to the amendment. The agreement is just simply evidenced by an email from the judicial officer which says, as agreed during, I can take you to the email if you want to see it, but paraphrasing, it says, as agreed during the discussion, however one terms it, in the Small Claims Tribunal, Mr. Gray has got permission to amend his claim. And then there's been some debate between the parties as whether it was actually an amendment, because the correspondence from Mr. Gray indicated that he wanted to amend to bring what now appear as substantive claims in the CFI, but I don't think it's seriously being contended that there was a waiver, and if it is and it's being pursued, then we would adduce evidence which is already before the court below and before this court, that from the very outset Gibson Dunn has said, well, we want to fall back on the arbitration in California, and indeed that was one of the reasons why the firm really didn't need to take much of a part in the Small Claims Tribunal proceedings, because as Your Honour has pointed out, the application in the small claims was to seek a declaration that the arbitration agreement was valid. So if one's talking about an abusive process, it's very difficult to conceive of an abusive process that's greater than the one that we've seen.
To the small claim?
Well, it was dismissed. Although Mr. Gray repeatedly talked about amending his claim, it was dismissed in April of this year. I think post consultation. I don't think it got to an adjudication. It didn't get to an adjudication stage.
It was dismissed on the basis that he was going to...
CFI. Yes. But because, and again, I think the formal line taken by Gibson Dunn is, you must do what you want to, and at the appropriate time we'll deal with the formal claim when it comes through, which the judge in the court below found was the case, and there's no appeal on his finding that the application was brought at the right time. It's a non-point. There's no point in dwelling on it. It's past. It's past history, but I just raised it in the context of my friend suggesting that there might have been a waiver of an agreement to arbitrate, and that's certainly not the case. I'm just sorry, could you just bear with me? Unless you have any further questions, those are my submissions.
Yeah, you're not making an application for this app.
To ask the court to consider.
You're not invoking Article 12.
No.
Thank you very much for your assistance. We will get back to you. A judgment months, and we'll get, if we have any questions, we'll get back to you further. And what do you want to do about costs? You want us to ask you for cost submissions, or are you prepared to take the consequences of costs following the event? The quantum is a separate thing, but
I think that there are two issues really. There's costs of the appeal, and then there was the issue of the costs at the hearing, they having not been dealt with. And I think I would certainly adopt my own friend's suggestion that we digest the board decision on the appeal, and then if needs be, perhaps written submissions on the question of the costs below could be made.
so. But you're content with the order made by Justice Shamlan as it stands?
Sorry, in what respect? In respect of costs, or?
No, just in the way that the order is framed, that there's a stay, and
yes, I mean he found that if for some reason the arbitration couldn't go ahead, then he found that the court has jurisdiction to hear the claim, and that's why he ordered a stay. That's my understanding of the order.
So there is
yes.
still a possibility of it coming back. It could still play itself out into another scenario. This is not necessarily the end of the
It could do
story in this court.
And we didn't cross appeal on his holding that it should be stayed rather than dismissed, which was open to him, and that was part of our application. But I'm content with the stay.
And the order that you want is as set out in your skeleton, or
It was
find it at all?
Your Honour, I think it was appended in the. I'll try and turn up the reference.
Supplemental skeleton, or in the original skeleton?
I think it's in the appeal.
Checking your
Bundle at volume 7, tab 7, volume 1, page 53. Is a draft order that we would ask to be
Right.
substituted. Sorry, the volume 1 of the appeal bundle, page 53, Your Honour, is the draft order that we we attached 2 draft orders to the application for permission to appeal. The first draft order was in respect of granting leave, and the second draft order, which is found on page 53, is the substituted for the order.
Where the
below.
set?
That the judgment be set aside and that the defendant respondent pay the claimant's costs. Very straightforward. It's simply.
Which what?
52 was the draft order on the application for leave to be granted permission to appeal.
But that's taken care of.
Yes, sir. Yes, Your Honour. So 53.
And the substantive submissions in support of this are found in that you dealt with it
In read together, Your Honour, in the skeleton argument, which you had in the bundle.
skeleton for this appeal.
Yes, Your Honour, and then the supplementary skeleton argument, which I've handed up to Your Honour.
Also in the supplemental skeleton. Okay.
Rise.